quelques minutes.
Yes, se você tem aqui questões, é capaz de documentos, mas por isso é de se você tem aqui issues. Yes, se você tem aqui questões, é capaz de documentos, mas por isso é de se você tem aqui issues.
Anouk, te pensez nous attendre quelques minutes ou sans nous commencer? Parce que nous avons, vous pensez nous reach 20 minutes?
Yes, nous avons une bonne quantité, nous avons mis nous 94 là, et live là, YouTube, nous environ 40. Donc, yes, c'est un bon parti, fini join, nous sommes capables de commencer.
Okay, nice. So, hello everyone. Now that we are all connected, we can start our webinar. Good afternoon to you all. It is an immense pleasure to welcome you all to this webinar on human rights in association with Maître Kumaran Ramasamy, barrister at law. Maître, est-ce là?
Yes, good evening, everyone.
Hello. Okay, so I present myself, Sadia Netsingen, founder and president of Project Humanitarian Hands, which is an association of youngsters working on a common goal, which is social improvement. I'm currently doing my Bachelor of Laws LLB Level 3 at the University of Mauritius and your Master of Ceremony for tonight. So I would now like to introduce you to our speaker, Maître Kumaran Ramasamy, who was previously the Secretary of the Environment and Land Use Appeal Tribunal from 2014 to 2020. He holds a Bachelor in Law LLB and an LLM in International Business and Commercial Law. Maître Ramasamy is a member of the Mauritius Bar Association and has previously served in the Legal and Compliance Department of an offshore management company. Please note that at the end of our webinar, we'll have a Q&A session for your questions, and also a link will be sent 5 minutes before the end of the session for the certificates. Please do fill it, as you won't get your certificates, and both those who are attending through the Gmeet and through YouTube will be eligible for the certificate. The link will be sent on YouTube as well. I would now like to yield the floor to Maître Ramassamy. Thank you. Matt?
Thank you, Sanjana. Can you hear me well? Firstly. So you can hear me properly, yeah, before we start.
So, we can't see you.
Okay. Now?
No.
Yes, actually we can.
Yeah.
Okay.
So,
Maybe you just have
I
to
got
pin Met Sanjana. You have to
Okay.
pin the presentation.
Okay, sorry.
okay, that's all right. So let's start. Firstly, thank you to Project Humanitarian Hands for the invitation. And thank you to Sanjana and Yashil for the organization and the whole team. It is a great pleasure for me to be able to address you all this evening. So thank you to everyone who are attending. Firstly, it is important to understand that human rights is a very vast topic. Okay, so 1 hour is impossible for me to do justice to the topic itself. But what I have done is I have selected the salient aspects of human rights for you all to get an understanding of its importance. So, as you can see, the title itself is an introduction to human rights in the Mauritian context. It is just an introduction, but it will help you to further better your knowledge of human rights. So to start with, we can start with the statement of the great Nelson Mandela, who stated that to deny people their human rights is to challenge their very humanity. This simple statement means a lot, to the extent that what the great Nelson Mandela meant is to deny people of their human rights is actually denying them their very existence. Therefore, if their existence is no more, they do not actually survive. Basically, what I mean is human rights is very important for the survival of mankind to the extent that it brings about a democratic society. Without human rights, we would live in a barbaric society, if I may use the term. So this is an aspect that I wanted you to understand, because human rights is unfortunately misunderstood in every society of the world. Further, Justice Derogations Basu, who is an eminent Indian jurist and lawyer, stated that human rights are those minimal rights. Minimal, you may assume that not of great importance. Minimal rights which every individual must have against the state or other public authority by virtue of his being a member of human family, irrespective of caste, color, creed, place of birth, sex, cultural differences, or any other consideration.
So, sorry to disturb you. You have a background noise.
Okay, just bear with me. Is it better, Sanjana?
Yes.
Okay, thank you. Yeah, so what I was saying is that in the statement of Justice Derogations Basu, there is what you call a protection that is afforded to every individual against the state or public authority. Therefore, this provides a checks and balance on the authority imposed by the state or any public authority. Another way of imposing a checks and balance would be by way of judicial review. But now we're concerned with the human rights provisions in a democratic society. Therefore, human rights ensures that every human being is treated with dignity. Now, what is the origin of human rights? Is a debate in itself. We, as legal persons, would tend to think that the origin of human rights would be legal sources such as treaties, conventions, and legislation. However, human rights also finds its place in the holy books. I have listed a few extracts. For example, in the Atharva Veda, all human beings have equal right over food and water. Food and water is a basic human right, and this is found in the Atharva Veda. In the Tirukkural, it equally emphasizes that the vital principles of non-violence, vegetarianism, costlessness, and brotherhood, all these aspects, especially costlessness, is a way of non-discrimination, which is found, we have already seen in the statement of Justice Basu, and later on we will find it is in the Constitution of Mauritius as well. The Quran states that all humans are the descendants of one man, Adam, and are therefore brothers to another. The emphasis on equality and justice in the Quran appears throughout the text and even include one's enemy. In the Bible, the late Max Stackhouse, professor and director of Kuiper Center for Public Theology at Princeton, he explained that intellectual honesty demands recognition of the fact that what passes as secular Western principles of basic human rights, in fact, develop nowhere else than out of key strengths of the biblically rooted religions. All these extracts show that human rights is not only an emanation of law, conventions, treaties, but also it is found in ancient holy books, ancient texts, which shows you that as much as the holy texts preach equality, so does the legal sources of human rights. Now, what are human rights? They are basic rights and freedoms that belong to each person in the world, from birth to death. They apply to each individual, regardless of his or her nationality, place of residence, sex, national or ethnic origin, religion, language, or any of the states. Therefore, human rights are universal rights, which are interrelated and interdependent and indivisible. From this definition, again, the basis is that there should not be any discrimination. There is the concept of equality, and the concept of equality and non-discrimination, we will see later on, is also found in our Constitution. So the Universal Declaration of Human Rights is the world's premier human rights instrument adopted by the United Nations in December 1948. Since then, the human rights have evolved significantly and are now expressed and guaranteed by law Okay, in the forms of treaties, as I was saying earlier, customary international law, general principles, and other sources of international law. In Mauritius, most of the fundamental rights and freedoms of the individual are guaranteed under the Constitution. Now, human rights, although we have seen its origin in sacred texts and the law, it did not come about voluntarily or easily. We had had a long process of evolution for human rights to come about. And human rights basically distinguish human beings from other species. There have been times in the past where there have been oppression and suppression of human beings by other human beings themselves, which led to struggles and revolutions. And for the restoration and protection of human rights and fundamental freedom, those struggles and revolutions were important. And one concrete example is slavery. The abolition of slavery only came about after struggles and revolutions. And if you look at it, slavery was a form of discrimination to the extent that inhumane treatment were being inflicted on human beings. And protection from inhumane treatment is a fundamental human right which is found in the Mauritian Constitution. So arguably, slaves had to overcome such treatment through long struggles and revolutions for us to achieve what we now celebrate, the abolition of slavery. The state of Mauritius is a party to a series of regional and international human rights instruments. I have listed the main ones. One important instrument is the International Covenant on Civil and Political Rights. You have also the International Convention on the Elimination of all forms of discrimination against women, very important. And also the Convention on the Rights of Persons with Disabilities. In regards to this convention, I am of the opinion that we have a lot of progress to make in Mauritius. Of course, there is already a lot of work which is being done in this regard. You have associations and foundations such as Global Rainbow Foundation who are doing a very good work in this regard, but of course, we have a lot of progress to make so as to ensure the rights of persons with disabilities are improved even further. Now, we also have regional human rights instruments en ce qui concerne l'Afrique. We have the African Charter on Human Rights and People's Rights. Also, we have the African Charter on the Rights and Welfare of the Child. All these instruments, albeit on a regional context, are very important, and Mauritius have either ratified or acceded to say. Now, in furtherance of its engagement, international and regional engagement, to those conventions and treaties, the state of Mauritius has also set up a series of independent national human rights institutions. And these institutions have the core function to protect and support the citizens of the country in the prevention of human rights violation and abuses. You have the Equal Opportunities Commission, the Ombudsperson for Children's Office, the Office of the Ombudsman, Independent Police Complaints Commission, the National Human Rights Commission, the Ombudsperson for Financial Services, which is the latest creation. All these institutions, they have a very significant role to play. For example, the Equal Opportunities Commission. Anyone who suffers any form of discrimination, being at work or any other sphere of life, they have a right to go and make representation before the Equal Opportunity Commission. You have the Ombudsperson for Children's Office, very important institution for the protection of the rights of children. Also, the Independent Police Complaints Commission, a new creation as well, whereby any person who are detained by the police and have suffered any police violence, they can always make their complaints to the Police Complaints Commission, Independent Police Complaints Commission. Now, tout ça pour dire, qui me peut dire par cette institution-là, c'est qui nous pays, c'est-à-dire les Maurice, il fait beaucoup de progrès sur l'engagement ou la protection des droits humains. La création de cette institution-là est capable de paraître simple et banale, mais je apporte une contribution énorme pour assurer qu'il y ait un accès facile des individus à la protection des droits humains. So, the engagement of Mauritius to ensure the protection of human rights is not to be doubted. But as I said earlier, there is always room for improvement, and also in practice, how this institution performs is important. The institutions, they also contribute for the advancement of the rule of law, and they strengthen the participation of civil society. Alors, la société civile, il y a tout le loisir pour participer dans l'engagement qui le pays a pris, c'est-à-dire en ce qui concerne la protection des droits humains, et ça va institution-là assurer que la société civile est dans son mot à dire pour la protection des droits humains en faisant en sorte que l'accès à cette institution-là est facilité étant donné qu'il est regroupé en termes d'activités qu'ils ont occupées. Par exemple, we have the Financial Services Ombudsman qui occupe l'aspect financier. Okay? C'est-à-dire une bonne concentration de fonctions sur une seule institution, mais plutôt reparti dans différentes institutions. Alors ça faire en sorte que l'accès à cette institution-là est plus facile s'il est concentré dans une seule institution. Now, let's move to the legal definition in the Mauritian context. We have the Human Rights, Protection of Human Rights Act 1998, whereby you have a very basic definition of human rights. And I don't even find it to be a definition, because what it says is that the Protection of Human Rights Act states that any right or freedom referred to in Chapter 2 of the Constitution is human rights. So basically, you have a text, a legislation which deals with Protection of Human Rights Act, but the definition in that text is a referral to the Constitution. So there's no definition as it is, but rather it just sends you back to the Constitution. And the Constitution, under Section 2 of the Constitution, it is stated that the Constitution is the supreme law of Mauritius. And if any other law is inconsistent with this Constitution, that other law shall, to the extent of the inconsistency, be void. So as you can see, the Constitution is the supreme law of Mauritius. Alors, n'importe qui la loi qui peut être contraire à la Constitution, ça la loi là, il peut void to the extent of the inconsistency. Tout texte de loi doit être conforme à la Constitution. Pareillement, le Protection of Human Rights Act 1998, it has to be in conformity with the Constitution. So, even if we have a law which concerns the human rights, rather the substance of human rights legislation is found in the Constitution. And under Chapter 2 of the Constitution, there is a list of protection of fundamental rights and freedoms of the individual. We have, for example, starting point, always Section 3, fundamental rights and freedoms. There's a list under Section 3. And the main types of protection that is afforded under the Constitution: protection of right to life, protection of right to personal liberty, protection from slavery and forced labor. This is what we were talking earlier. So slavery is not allowed anymore, but at one point in time, this was a reality. Protection from inhuman treatment, protection from deprivation of property, protection for privacy of home and other property, provisions to secure protection of the law. And Section 10 of the Constitution is a very important section because there's a list of rights which are provided under Section 10 of the Constitution. For example, access to counsel by a person suspected of an offense is provided for under Section 10 of the Constitution. Also, the right to be afforded all facilities to prepare one's defense is found under Section 10 of the Constitution. And also like that, we have a series of protection which are found under Chapter 2 of the Constitution. So, if you want to find which of your fundamental rights are being infringed, your starting point is Chapter 2 of the Constitution. So anytime you have any doubt as to whether any treatment being afforded to yourself or any other individual might be an infringement of the fundamental human rights, the starting point would be Chapter 2 of the Constitution, and you see under Chapter 2 whether you fall under any of the provisions in there. We have seen that the Constitution is the supreme law, but does that mean that the Constitution is above anything else? In a way, yes, it is above any other law, but nevertheless, the Constitution has its limits. And the Constitution of Mauritius is limited in the sense that it protects only civil and political rights. And Mauritius being a welfare state that protects economic, social, and cultural rights, such as health and education, through acts of parliament. So the Constitution is tested to that extent. That is, it has its limits. It is not absolute. So the protection that is afforded under the Constitution, very important, it is a supreme law, but it is not an absolute protection that is afforded. So it has its limits. We have spoken about Section 3. Section 3 states that it is hereby recognized and declared that in Mauritius there have existed and shall continue to exist. And this is what is important. We were looking at earlier the aspect of discrimination. Okay? And this is where it is found. Section 3 of the Constitution shall continue to exist without discrimination by reason of race, place of origin, political opinions, color, creed, or sex, but subject to respect for the rights and freedoms of others and for the public interest. This takes us back to what was stated by Justice Basu. Justice Basu was talking about the aspect of discrimination. So irrespective of your color, creed, or sex, whatever, you have to be protected. You should not be discriminated against. But there is a clear qualification in the Section 3. Your right is subject to respect for the rights and freedoms of others or for the public interest. And in Mauritius, unfortunately, there is a mistaken belief that human rights means that you can do whatever you want under the context of freedom. Okay? Unfortunately, this is not the case. You have rights, you're protected under the law, you have fundamental rights and freedom, fair enough, but your right stops where other people's rights start. So this is what is lacking in the Mauritian society. Very often you see that there are debates about freedom of expression being infringed, but what is not understood that yes, you have a right to express yourself freely without any control, but you as an individual, you should have the responsibility and the due diligence to know what you're talking about. And in your freedom of speech, you should not be infringing the rights of other people. So there should always be a balance. Freedom, human rights is not an absolute right. Okay, so it is a right for you, but it is also a right for someone else. So there should be a balance between where your right starts and stops. So are human rights and freedom absolute? Justice Basu stated that the welfare of the individual as a member of the collective society lies in a happy compromise between his rights as an individual and the interests of the society to which he belongs. There is no protection of the rights themselves unless there is a measure of control and regulation of the rights of each individual in the interest of all. So this is what I mean. Your right is not absolute. There should be a compromise between your right as an individual and the interest of society. So, in no way should it be taken that your freedom, your rights are absolute rights to you only. There should not be the aspect of only individual rights, but it should be your rights as an individual balanced with the interests of the society at large. So the statement of Justice Basu finds credence in our Section 3 of our Constitution, where it is stated that human rights and fundamental freedoms are protected, but subject to respect for the rights and freedom of others and for the public interest. Earlier, I stated that the rights and freedoms found in the Chapter 2 of our Constitution, they are not absolute. And this is confirmed even further by Section 18 of the Constitution, which provides for derogations from fundamental rights and freedoms under emergency powers. So, nothing contained in or done under the authority of the law shall be held to be inconsistent with or in contravention of Section 5 or Section 16, to the extent that the law authorizes the taking during any period of public emergency of measures that are reasonably justifiable for dealing with the situation that exists in Mauritius during that period. Provided that no law, to the extent that it authorizes the taking during a period of public emergency, other than a period during which Mauritius is at war, of measures that would be inconsistent with or in contravention of Section 5 or Section 16, if taken otherwise than during a period of public emergency, shall not have effect unless there is in force a proclamation of the President declaring, because of the situation existing at the time, the measures authorized by the law are required in the interest of peace, order, and good government. And this was in the limelight lately with the COVID-19, whereby certain decisions have to be taken due to Mauritius facing the pandemic. Okay, so Section 18 provides for derogations from the fundamental rights and freedoms which are guaranteed under the Constitution. What was the impact of the COVID-19 on human rights and fundamental freedoms? We may not have realized it, but the impact were of great importance to the extent that they, in a way, infringed a lot of fundamental rights. But as I told you, fundamental rights are there, they need to be protected, they are afforded protection under the Constitution, but there are times where you are allowed, as provided for under Section 18, for example, you are allowed to derogate from those fundamental rights. So the very nature of COVID-19 has pushed governments worldwide, not only in Mauritius, but worldwide, to take drastic actions which inevitably affected fundamental human rights. And Mauritius was not the exception, and many people in Mauritius felt that their rights in the Constitution were to some extent infringed. Okay? And the main rights which were affected will be looked at in the following slides. So what is the impact of human rights as a result of, on human rights rather, as a result of COVID-19 pandemic? The important sections that we will look at are Section 7, 10, 12, 13, and 15. Section 7 provides for the protection from inhumane treatment. Section 10, provisions to secure protection of the law. Very important section. Many of you are law students, so you need to understand that Section 10, especially if you're going to practice law one day, it is a very essential section of the law which provides for very important protections to people who are suspected of offenses, for example. So the Constitution, as a law student, should be your Bible, if we may put it like that. So you need to know the Constitution because many cases are won and lost based on constitutional points. Okay. So Section 12, which is always a great debate, protection of freedom of expression. In Mauritius, every day you have that debate. And also Section 13, protection of freedom of assembly and association. Another important protection which was arguably infringed during the COVID-19 pandemic, and it is still in a way being infringed, but it is a necessity to do it because of the special situation, or rather not special but unfortunate situation that we find ourselves in. Then you have section 15, which provides protection of freedom of movement. So section 7, protection from inhumane treatment. No person shall be subjected to torture or to inhumane treatment or degrading punishment or other such treatment. Qui ça veut dire? C'est-à-dire, tout être humain pas droit être subjecté à la torture ou tout autre traitement qui pas un traitement humain ou un traitement qui dégrade. Par exemple, un individu est arrêté par la police, okay? Suspected of the commission of an offense, is arrested by the police. Fair enough. That person, he has rights under the Constitution. That person has a right to counsel. That person, quand il peut donner ce statement, par exemple, il a droit à un break. OK? S'il peut donner ce statement à la police, bien sûr, s'il a envie de retenir un service d'un avocat, bien laisser retenir un service d'un avocat. S'il n'est pas capable de faire de service d'un avocat, bien guetter s'il est éligible pour legal aid. OK? S'il n'est pas envie d'être représenté, il a le droit de se déposition, ce statement tout seul, mais il a une façon de faire avec la personne. Par exemple, la police n'est pas capable, pas donner à la personne quelque chose à manger ou à boire pendant, let's say, des heures. La police n'a pas le droit de continuer, prendre ce statement sans donner une break, toilet breaks, anything that that person needs. So if the police carries their statement recording without affording those fundamental rights, that person will be subjected to what we call inhumane or degrading treatment. Now, such treatment may be when that person is already convicted and serving his sentence. So such treatment can be found or can be experienced in prison, for example. Even in prison, if you're convicted, you have certain rights. You have right to get food, water. So if you are deprived of all these rights which are found under the Constitution, then you are being subjected to torture or inhumane or degrading treatment. So, section 7, il fait en sorte qu'il protège tout individu contre any treatment which would qualify as a degrading or inhumane treatment under section 7 of the Constitution. Now, how was section 7 affected by the lockdown? So let us take it into a more real situation which happened recently. We had curfew orders which were in place in the first lockdown in 2020. And anyone who were acting in breach were liable to a fine and imprisonment. Okay. The police, they were mandated to ensure that people were respecting the terms of the lockdown of curfew orders, but they were not mandated to use force to enforce the regulation. They are allowed generally to use reasonable force in the performance of their duty that is proportionate to the attack being inflicted upon them. During the first lockdown in Mauritius, several videos have been posted on social media showing that the police are using excessive force with citizens to ensure that compliance with the curfew order, to ensure that there is compliance with the curfew order. And one such incident was in March 2020 when the police resorted to excessive use of force in retaliation to projectiles being thrown at them upon trying to disperse a crowd.
I can hear you.
Okay. So let's continue. So the treatment afforded to that individual during their detention by the police was arguably an inhumane treatment which is prohibited under the Constitution. Under Section 10, which provides for the protection of the law, where any person is charged with a criminal offense, then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. That is provided for under Section 10(1) of the Constitution. And Section 10, as well, there were situations during the lockdown which affected Section 10 of the Constitution. In what way it affected Section 10? Because of the lockdown, there were disruptions in court proceedings, and the courts were handling only urgent matters through technological means. Matters such as bail, cancellation of arrest warrants, protection orders for women and children victims of violence at the district court level were being conducted online through teleconferencing. However, despite these steps, other matters had to be put on hold, and as such, the trial period were being delayed, thus violating the principle of trial within a reasonable time. Alors, qui nous veut dire par ça? Le fait qu'il finit un arrêt dans plusieurs banquets la cour pendant le lockdown, parce que qui fait arriver à cette situation-là, parce qu'il nous pas prévoir how to deal with such a situation. Il y a un affaire nouveau, surtout because first lockdown. Alors, tout le monde, y compris le judiciaire, s'y est pris à coup. Alors, passer là en place un système how to ensure that court proceedings are not stopped. Malheureusement, si finit dans une case qui finit tout repoussé, pas n'écoute pas une case ça. Il y en a beaucoup convicts or people who were detained and who were on remand. They had to wait longer for their case to be heard and for them to get their liberty. Alors, inévitablement, finira un breach de section 10.1 de la Constitution. Now, section 12, which deals with protection of freedom of expression. Very important section, and it is a section of the law which is regularly being in the limelight for good and bad reasons. So you have under section 12.1, except with his own consent, no person shall be hindered in the enjoyment of his freedom of expression. That is to say, freedom to hold opinions and receive and impart ideas and information without interference, and freedom from interference with his correspondence. Now, as I told you earlier, no right under the Constitution, no fundamental rights and freedom of the Constitution is absolute. And same applies to section 12 of the Constitution. You have a right to express yourself freely. But this does not mean that you can say anything you want. You have to be responsible and diligent in your way you express yourself. This is the basis of a democratic and responsible society. And Section 12 is a major debate almost every day in Mauritius. Since the outbreak of COVID-19, worldwide, many governments are struggling to contain what you call fake news. And the same is the case for the government of Mauritius. For instance, on 24th March 2020, there was a publication of fake news about looting and rioting in one part of the island on Facebook. And this was done by responsible people, not people who do not understand the importance of transmitting such news. So that individual was arrested and charged under the Communications Technologies Act, Information and Communication Technologies Act, and they are on bail. The government has been very strict in response to the publication of fake news, but also there have been arguments that simple jokes on social media are being targeted as well whenever they are against the government. And there was one person who was arrested for posting a meme against the government on social media. It was argued that this arrest demonstrated that the government is not respecting freedom of expression. But in my opinion, the question that needs to be asked is whether the excuse of meme is good enough to justify such post. Is the individual, in doing so, not crossing the fine line between society, whereby social media is now the norm of communication? But as any other form of communication, in my opinion, it should be a responsible communication. People cannot, on the excuse of using the platform as a joke, make statements, albeit in a form of a joke, which are not the truth. So the veracity of any such statement, in my opinion, needs to be ensured before posting, because there are millions of people who follow social media. And one example is the post on looting and rioting, which was posted on 24th March 2020. This was a very irresponsible form of communication, which was done. And this can in no way be said to be a freedom of expression. As I told you, no right is absolute, so same applies to Section 12 of the Constitution. Now, there have been amendments which have been proposed to the IBA Act recently, and the object of the bill is to amend the IBA Act in order to provide a better legal framework to regulate licenses of the authority. There is a debate about this as well. So, one among the critics against the proposed amendments, they qualified the proposed amendments to the Independent Broadcasting Authority Act as a sledgehammer for freedom of expression. This, we will see in time what is the intention behind the proposed amendments. If the amendments is being done in good faith, fair enough, but only time will be able to show whether the apprehension that are there are justified or not. Section 13, protection of freedom of assembly and association. Very important. And Section 15, protection of freedom of movement. So these two sections, they are in a way connected. And again, during the COVID-19 and the lockdown, during the curfew orders, there were decisions taken by the government. The question that needs to be asked, does the ban on large gatherings violate Section 13? Section 2 of the Constitution, we have seen, is that the Constitution is the supreme law, and any law which is inconsistent with the Constitution would be void. So a literal interpretation of this section indicates that any step taken by government to combat COVID-19 has to be in line with the Constitution. Now, therefore, regulations and orders have to meet the limitation requirements set out in the Constitution. As demonstrated, both the freedom of movement and freedom of assembly can be limited in Mauritius. In addition to the limitations provided by the different sections, Section 18 of the Constitution provides for derogations, we have seen it, from fundamental rights and freedom under emergency powers. Therefore, the government does have a broad power to suspend constitutional rights in times of emergency. However, although Mauritius considers COVID-19 as a sanitary emergency, it did not declare a state of emergency under its constitution, but rather adopted the measures through regulations and orders. In so doing, the government could not rely on Section 18 of the Constitution as a justification for limiting those fundamental rights, since the government did not go through the Constitution, but rather through regulations and orders. Now, since Section 18 could not be used, the other alternative was to analyze whether the regulations and orders adopted under the different acts of Parliament could limit the rights in the Constitution. And the government has adopted laws such as Public Gathering Act and the Derogations Act to limit the rights in these two sections, that is Section 13 and Section 15. And the wordings of the two sections and the Constitution generally may lead us to believe that the government could only do so through acts of Parliament. However, we have the very important case, the case of Duki against Passport Immigration Office, 1987 case, which confirms that the regulations adopted under Acts of Parliament are part of the Acts and can therefore limit the rights in the Constitution. This statement demonstrates that the court considers the passport regulations as a law, and this can limit the rights in the Constitution. So the decision of the Supreme Court in the case of Duki can be extrapolated to the current situation whereby regulations and orders were adopted by the Minister of Health under Acts of Parliament, which are considered as laws, and therefore they can limit the rights in the Constitution. Therefore, the exercise of those powers were reasonable and justified, since they had been adopted to combat the pandemic, that is, a contagious virus that has been considered as a global pandemic. Internationally, what is the view in this regard? For example, Neil Devins, a constitutional law professor, stated that it may raise an issue of freedom of assembly or some other constitutional right, but so long as the government has compelling justification and no better alternative, the government can place limits on rights. Okay? Judge Campbell, a constitutional law professor with the University of Richmond, said that those types of restrictions have been in place since the early 1800s, when the country had frequent epidemics of yellow fever. During that time, the US Supreme Court had cases to discuss government rights during a pandemic, which still apply today. State governments have the right to place restrictions only if they are doing so in an even-handed manner. Alors, ça veut dire, tout saban case qui est à Maurice ou bien dans case à l'étranger, il montrait que si le gouvernement peut bien agir dans un temps de pandémie, par exemple, it is justified to limit those rights even if you do not do it through the Constitution. You can still do it through regulations and orders, and it is not illegal. And as you may have seen during that time, there were arguments to the contrary. C'est un argument qui vient dire que le fait qu'il passe par la Constitution ou par une legislation et qui ne fait aller par une regulations illégales. C'est un argument là par un parlementaire, une personne qui parle parlementaire. Mais from the analysis that we have done, it can be argued, and it is rightly argued, that the actions taken through regulations and orders were not illegal, but were justified under the specific situation that we found ourselves, that is the pandemic. Now, we have seen the impact of the COVID-19 on the fundamental rights. But what are the lacunas found under our Constitution? We are looking at fundamental rights. One of the lacuna under the Constitution is protection of the environment. Okay? This does not have a constitutional status. And why it does not have a constitutional status, I leave it to you to try to understand why. But the Environment Protection Act 2002 is the main legislation in regards to the protection of the environment. And Section 2 of that act, it has a very interesting aim under Section 2, which is environmental stewardship. It is declared that every person in Mauritius shall use his best endeavors to preserve and enhance the quality of life by caring responsibly for the natural environment of Mauritius. However, in practice, Section 2 of the EPA does not have much weight as opposed if it was a fundamental right provided for under the Constitution. So one of the lacuna of our Constitution is the protection of the environment. There is no provision as such under the Constitution whereby a citizen could rely on same to say that there is a breach of my fundamental right to be provided with clean air, for example, to be provided with sea, which is not polluted, for example. Unfortunately, there is no such protection under the Constitution. It is found under the Environmental Protection Act, as I told you. Unfortunately, in practice, it does not carry much weight. So hopefully in the future, there will be a provision which will be incorporated under the Constitution for the protection of the environment. Now, as a conclusion, human rights and freedoms are hard-fought rights and should be preserved as much as possible. As we have seen earlier, these rights did not come about automatically. There were struggles to bring about such rights to be recognized. However, none of these rights are absolute, as we have seen, and therefore they can be restricted provided it is done even-handedly and reasonably for a proper purpose, such as a public emergency. Therefore, it can safely be concluded that there must be a balance between the right of the individual and that of society at large. So my advice to you, future barristers, lawyers, or academics, or anyone from any other sphere of life, when you are going to exercise and fight for your rights and freedoms under the Constitution, do so responsibly. Do not blindly listen to people who tend to make you believe that your rights are absolute rights. This is not the case. Because you have to respect the rights of other people. So your right stops where someone else's rights stops. So this is important. And thank you for your attendance. So any questions? I will take any questions that you may have.
So I hope now you're more confident about your basic rights as human being. I personally had know a lot of people who are not aware of their rights. So stay tuned for more events like this one where you can learn more. And also the G form, Google form will be sent in the chat box on both YouTube and Gmeet. You can fill it meanwhile. We attend to the questions. So, and also we'll send you the LinkedIn link for Mr. Kumaran Ramsamy and myself if you have any further questions, because we will take only 3 questions, unfortunately. And you can ask on LinkedIn. So we are open to questions. I would like to also thank Met for this nice workshop. I would like to thank my PHH team, organizers, Yashir, Nikhil, Mokshada, Pawan, Nidish, Yamini, Shane, Mandira, Karen Singh, Gwendoline, Derek, and my Shivesen. And also everyone who attended, thank you for making this workshop a great one. So we are now open up for questions. Thank you. You may raise your hands, please. I have my senior right here wanted to answer a few questions. Oh, Hitesh. Yeah, another senior. Hitesh.
Thank you, Sandiana. So, good evening, Met Kumaran. Good evening, everyone. So, I am Hitesh Situel, a former LLB student at UM and currently doing my law practitioner vocational course. I had one point that I wanted to point out and have the views of Met Kumaran upon it. So we have, despite having the constitutional right of right to personal liberty, I think that this right is very much infringed in our country, and we must all be aware of it. We have a unique system of provisional charge, and that unique system, we don't have it in other countries. What I want to point out is that a person is arrested in Mauritius upon mere facts. So it is such that inquiry has not been completed, no enough evidence has been gathered to formally charge a person. And the law provides no time limit to the police for the police to complete the inquiry. Now, what happens if that person is remanded to police cell or to jail? Now, there is a possibility that this person is innocent because we have the presumption of innocence. So there is a possibility that someone spends days, weeks, months, or even years in police custody, and later on, when the case is completed, the result is that this person is innocent. So this is a huge breach of human rights. So I wanted to have the views of Met Kumaran or anyone upon it, so we can know whether that criminal justice system that we have, whether it is in line with human rights as far as it's concerned the provisional charge system. Thank you.
Thank you, Hitesh. Very good point, and I agree with you. Unfortunately, this system has been in place for ages now, and as you rightly said, it is in contravention with a very fundamental right of the right to be considered innocent until proven guilty. Okay? The justification for such action is that whoever is arrested has to be brought under judicial control. That is, they cannot stay forever under the control of the police. But as you rightly pointed out, many arrests are simply done upon mere allegations without any complete inquiry being done by the police. And again, as you rightly said, there is no time limit on the inquiries, but their counsel for the person who has been arrested has to ensure that there is no unreasonable delay by the police when they come to court for the release on bail. The mere fact that you have not completed your inquiry cannot deny someone of their liberty, because liberty is the rule, detention is the exception. And it depends on how the bail hearing is conducted. But in my opinion, the solution for same would be electronic bracelets. Okay, so this has been recommended very long time ago. If you arrest someone and you have an apprehension that that person would escape from the police or the court system, you can always release them with an electronic bracelet, and you can always locate where that person would be. But this is an ongoing debate, and I agree with you. It is in breach of the basic human rights, because many innocent people are arrested and remanded to jail, awaiting firstly for their bail hearing, secondly for the case to be heard, which may take years, and these people would be found innocent after maybe 10, 20 years. And they have, during that time, lived with the stigma of being suspected of a crime. So I agree with you, unfortunately, but in this context, there should be a lot more that needs to be done, be it by ourselves, practitioners, or the civil society, to fight for the abolition of provisional charges. Thank you.
Thank you, Maître Comarin. Thank you.
Yes, yes.
I would like now to take the question of Nilam. If you can unmute yourself, please. And hello. Okay, so we'll proceed with Rahir.
Yes. Sorry. Can I speak?
Yeah, of course.
Yeah. So the question that I was asking was, according to you, during the COVID-19 lockdown period, do you think that the law has been able to protect the rights of victims of domestic violence, or has it been too focused on COVID-19?
There have been steps which were taken to ensure protection of people from domestic violence, but unfortunately, in my opinion, it was not enough, because during the lockdown, many people who suffer from domestic violence found themselves locked with their with the people who normally assault them, unfortunately, and the ministry, as long as I am aware, did take some steps to try to provide such people with hotlines, etc. But nevertheless, I don't think it is enough which was done. But on the other hand, we had a pandemic, okay? A pandemic which required urgent measures to be taken, and there was no other way around. The decisions for the lockdown had to be taken, and it was at the expense of people who, like you rightly pointed out, suffered from domestic violence. So my opinion is there is more to do in that aspect. we have to have a proper debate on same. But I agree that it was not enough to protect these people.
Thank you, sir.
Thank you.
Okay, so now it's Rahil's turn. Rahil, can you?
Good evening, Matt. So my name is Rahil Mandaran. I'm a freshly graduate LLB at the University of Mauritius. So I have a two-part question. The first part regarding the Constitution. So the Constitution provides for rights from Section 3 to Section 16. However, we have several rights that unfortunately is not incorporated in Mauritius. We have right to healthcare, especially in COVID situation. Right to education, again, especially in COVID situation, because there is a lot of children, unfortunately, do not have a digital tool to conduct online education. So my first question is, do you think now we should we should consider it urgent matter to incorporate this right to healthcare under the COVID situation and right to education under the COVID situation? My second part is, if we don't have right to healthcare, for example, I'm taking right to healthcare as an example, or even right to education in our constitution, can we enforce it to the Supreme Court before a court of law? Because under Section 17, it states that Section 3 to Section 16 can be enforced before the Supreme Court. So how about the other rights? Rights are inherent. We also have a right to health care. So that's my question. Thank you.
Thank you, Rahil. Right to health care is not provided explicitly under the Constitution, but as you will be aware, we are a welfare state. Okay, so healthcare is provided to the citizen of the country. What deprived the citizens of healthcare during the lockdown, in my opinion, is the restraints that were placed on the freedom of movement of the individual during those time. It is not the healthcare which was not given to them. Maybe what you see is the way the system is, they could not provide sufficiently to these people. But in my opinion, although it is not provided for explicitly under the Constitution, but being a welfare state, we do provide for healthcare to our citizens. But deprivation of the healthcare was due to other rights under the Constitution being infringed. For example, freedom of movement, which was one of the major aspects which affected access to healthcare. Access to education, same thing, because freedom of movement, you cannot go to school. So this is the right, in my opinion, which was infringed under the Constitution, and as a domino effect, it affected access to education and access to healthcare. Now, your second part of the question, how to enforce it. If it is not provided for under the Constitution, then you have to look at it indirectly. If it was a case on which I was working, I would go under the freedom of movement aspect, and under the freedom of movement, I would say what are the rights that are being affected, which although are not found under the Constitution, but Mauritius being a welfare state, those are fundamental inherent rights which need to be protected for each individual. So yes, you do not have a way to enforce it directly under the Constitution, but indirectly it affected your freedom of movement, which in turn affected your access to education and access to healthcare. So in my opinion, we could go indirectly under the section which provides for freedom of movement.
Thank you very much, Matt.
Does this answer your question?
Yes, Matt. Thank you.
Thank you.
Thank you, Matt. Do you have time for one more question?
Yeah, sure.
Okay, so Shania, can you please unmute yourself?
Yes, hello everyone. Bonjour maître. So I would like to ask a question considering about COVID-19. So as you can see, the current situation of COVID-19, we hear many things about the services in hospitals and how the people there are being treated. Don't you think that the government somehow is breaching their right to live?
So can you repeat the last one? The right to?
Their right to live. As you can see, there are so many testimonies which are being diffused on radio or television or even in the newspapers. I am just a bit
You
more
mean
concerned about this situation.
the right to life, yeah?
Yeah, that's it.
Okay. I agree. We have some serious problems, and it is unfortunate that so many people are losing their lives because only the ones who are going through those tragedies would understand it better, the pain behind losing someone, and it is unfortunate. I agree more can be done. But also, I don't know if you would agree with me, there is a responsibility of each individual to ensure that there is no propagation of the virus. There are so many people, unfortunately, in Mauritius and elsewhere, they act irresponsibly. I will give you one example. If you go to the seaside, not so long ago, there is no social distancing. It's not the role of the government or the police to come and control social distancing or to check whether someone is wearing their mask at the seaside, because yes, they are the enforcement authorities, they have to do their job. But each individual have their own responsibility. As I told you, protection of right to life, it is a fundamental right, yes. But also each individual should contribute to make it happen. So yes, I agree. More can be done in the healthcare system to try to avoid so many deaths. But I would say also more should be done by the individual to ensure that there is a curb on the propagation of the virus, and in so doing, we would not make as if we overburden the healthcare system, and the healthcare system would not be saturated, and as a result, the healthcare system would be in a better position to look after those who are suffering from the COVID-19. So, in my opinion, it is a shared responsibility of the government and of the citizens of Mauritius. I hope this answers your question.
Yes, indeed, it answered. Thank you so much, sir.
Thank you. So, Sanjana, we okay?
Yes, I think we are good. Okay. So thank you, sir, again. It was really nice.
Thank you. Thank you to you all for the invite, and thank you to all attendees. It was indeed a great pleasure to share my knowledge with you. And if you have any other questions, do not hesitate. Sandiana will communicate my LinkedIn details to you. You can always send me a message. I will get back to you as soon as possible.
Definitely. And also, we've sent our Instagram page because we do quite a lot of workshops as requested, mental health workshops, some of you. We did one previously. Please follow us to know about our future workshops. Thank you again, sir. Thank you, my team. Thank you everyone who attended. And I think we can, please do fill the Google form. Do fill the Google form for your certificates.
Yes, Sanjana, maybe speak a bit about Worthy Warriors while they are leaving.
Okay, so Worthy Warriors. Nous, Ena, and Mokos en créole, okay, so Nous, là, Worthy Warriors. Worthy Warriors, c'est un mouvement qui nous crée, que nous gardons les autres NGO et tout, pour qui nous combattent la dépression. Comment je connais pendant le COVID, etc. Nous avons beaucoup de cas, etc. Je connais qui causaient, etc. Pas pour causer workshop, tout ça, des fois, n'est pas moi aussi. Mais même ça, nous essayons d'éviter depuis la cause. Par exemple, nous faisons un workshop, pas comment pour combattre la dépression, mais par exemple, comment pour tackle avec work pressure. Comment pour tackle avec ban pressure dans le travail. Comment pour be happy in your career. Parce qu'il nous adresse à la cause de dépression et pas à dépression vraiment. So, ça, c'est un peu Worthy Warriors. Merci beaucoup to join Kinjoy. Merci Roman Studio, Hitesh and Rahil. Extra content que tu join. And anyone can join. Et yeah, c'est un peu ça. Et s'il vous plaît, pas oublier remplir cette forme, sinon on ne peut pas gagner. Ne pas gagner certificat. Et thank you to ban organizers, nous, Nikki, Powen, Yamini, everyone.
Yes, je tenais à préciser que le recording de sa session-là est toujours available sur notre YouTube channel. Donc, subscribe, vous êtes capable de trouver nos anciens webinaires aussi qui nous disent pour Worthy Warriors. Nous avons how to help a depressed friend, etc. Donc, prenez le temps, check-les parce que définitivement, vous pouvez avoir un effet important là.
Yeah. And anyone, si vous avez envie unmute pour que j'ai ou pour demander pour qui ça fait about the workshop ou just free to unmute yourself. Et si c'est bizarre, n'importe qui l'aide, c'est grave, unmute. Je m'extra apprécié tout le monde qui join. Tout le monde qui join. Et aussi, guys, stay safe avec COVID-19 qui déo parce que, comme moi-même, everyone is infected and c'est pas facile pour get balance ou faire, etc. Et qu'après nous aussi, not risk. So please, everyone, it's really serious. Prends soin, prends toutes les précautions. Si un jour peut de l'armée et que je prends de l'armée back, je vais penser du moulin en colère, c'est parce que laisse-les en colère, papa, laisse-les en colère. Pas. Laisse-les en colère, mais juste, be safe, pas. Pas de chicken back, etc. Anyone is capable de unmute pour other band questions. Hitesh, tu join bientôt.
Yes, j'ai l'intention de plus venir, mais on a un empêchement. Et quand on rentre à casa, je trouve ça, mais là, vaut mieux que tard que jamais.
Yeah.
150 minutes, on va retard là.
So everyone is capable, et aussi est capable de join PHH, de faire un petit workshop, etc. De follow une page, comme ça, tu es capable de connecter dans les autres workshops. Oh, you want a hug? Big hug.
Hug Maïe, la bête, shake hand, même pas pécable là.
Si j'étais de cas une musique, nous faire connaissance. Si j'étais un point, je cas une musique, introduire, etc.
Tu commence par introduire toi-même, nous pas connu toi.
Non, mais beaucoup que moi. So, yeah, je tout commence à introduire. Comme ça, si tu as envie de join. It's an informal session, guys. The formal session has ended. It's really informal.